Thank you so much for joining us. This is a new attitude, OSHA's Enhanced Enforcement Program. My name is Michael Metz-Topodas, and I'm a partner at Saul Ewing in their construction group. We're going to take just a few moments to let some more folks join. I think we won't get fully underway for another few minutes or another minute or so as people are joining or perhaps gathering up lunch or who knows what. But before we do get fully underway, I just wanted to touch base on a few housekeeping announcements for those of you out there, in particular related to some of the administrative matters that go along with this webinar. When it comes to questions and answers, please submit those through the Q&A tool at the bottom of your screen. I probably will not answer questions as we go through. In fact, I'd rather just sort of wait till the end and then address them there. Some of them may or may not end up being answered throughout the course of the presentation. If they don't, of course, then we'll touch base on them or circle back to them at the end. And of course, I do want to at least reserve or leave some amount of time at the end of the webinar for any questions that might come up either related to what we're going to talk about or perhaps any other topic regarding workplace safety or workplace regulations, in particular those that come from OSHA, and any other OSHA-related matter that might be on your mind these days. Turning to CLE requirements and CLE credit, this program has been approved for one substantive CLE credit in Delaware, Florida, Illinois, Minnesota, New Jersey, New York, and Pennsylvania, with applications pending in California and Virginia. As a CLE provider, we must be able to verify your attendance. So therefore, at random points during this webinar, we'll display and verbally announce 2 numeric reporting codes that you must record and report back to us using the CLE survey that you have received in your webinar reminder email. The survey will also open automatically in your browser once this program is finished. We will then in turn send you your certificate of attendance once you receive your survey response. Please be sure to respond to the Saul Ewing CLE survey with your numeric codes within 5 days of the program. So just make sure you have that there. If there are any problems or issues or any complications with any of your applications for CLE credit, please don't hesitate to contact me. Just to let you know, the webinar is being recorded and you'll receive an email that'll have a link to that recording as well as any supplemental presentation materials. In other words, my slides. This provision, and then finally, just legal disclaimer here, in providing and for you receiving this information in this program is not legal advice. It does not create a lawyer-client relationship and should not be acted on without seeking professional counsel who have been informed of the specific facts of any matter you have. Sometimes too in the question and answer period, folks might have particular matters, and those also too probably are going to be best addressed offline. But certainly throw out any questions that you may have out there at the end. And so with all of that, why don't we get started? As I mentioned, this is a new attitude, OSHA's Enhanced Enforcement Program. And what we want to talk about is recent changes in OSHA's policies that have had an effect on how many in the industry, or many in this practice area, see its enforcement following suit. Like I mentioned, my name is Michael Metz-Topodas. I'm a partner in Saul Ewing's construction group. I work out of the Philadelphia office. You see there my full contact information. Feel free to capture a screenshot, but like I said, the slides will provide all of that to you. In giving any of these webinars, I always like to take a little bit to talk about myself, my practice, and my background, just to give you an idea of where I'm coming from in addressing any of these issues. I work at Saul Ewing in their construction group. As you see here are these 2 little symbols. My practice spans all aspects of construction, from initial bidding on projects, whether public or private, as well as contract review and contract drafting, various amounts of day-to-day business counseling. What that refers to is just advising clients as a project is ongoing on how to protect their legal interests throughout the course of the project. And then finally, I handle and litigate a great number of construction-related claims. And of course, that construction practice, you can see, is rather cyclical, and each element of it feeds upon the other. So work done on construction claims feeds a lot of the day-to-day business counseling and advice that I give. And of course, those day-to-day project issues feed how you draft and review an agreement. And of course, any kind of contract that arises or that initiates a project sometimes will arise and develop out of the bidding process beforehand. And so the representations that go into that bidding certainly can also become part of a contract. It actually will happen on construction projects. Related to that, of course, is my OSHA practice. Some of you may or may not know there's an entire silo of OSHA's regulatory scheme devoted entirely to the construction industry. Agricultural and maritime and arguably mining are the other three industries that have that kind of focus from the regulators and the regulations that have been, the workplace safety regulations that exist. So I've also done a lot of counseling and support to clients both in the construction industry related to those regulations, but also that work has grown into a lot of just, we call it 1910 OSHA, that is general industry OSHA, in particular in manufacturing, in manufacturing and supply industries. Those tend to be where you're going to see a lot of the greatest number of workplace safety issues. And for those of you maybe catching this, that is actually my OSHA card. My OSHA 10 certification card. I have taken the OSHA 10 course in support of my OSHA practice. Before becoming a lawyer, I actually worked as a teacher for 9 years, teaching high school social studies. My law school was at Temple University. That was in between the careers, obviously. Started off at Swarthmore College, and I'm living proof that a philosophy major can have a career separate apart from those who joke, let's say, working at Starbucks. People always want to know, especially those in the Philadelphia area, what are my team affiliations? One of the things I used to teach back when I was a teacher was psychology. And so there was always a lesson on subliminal messaging. And so for my own safety, I sort of leave it subliminal living here in Philadelphia. But turning now to our change in OSHA, I entitled this A New Attitude. In direct reference to Ms. Patti LaBelle and her famous song from the 80s. But I think that's really what we're seeing here in OSHA. I think attitude is one way of putting it. I think it captures the change that we're seeing in the regulatory landscape and also its enforcement. And we're going to talk about how all that comes in these particular 4 areas. Before I get into those, at this time, I'd like to remind you that your first of 2 CLE codes is being presented. That is code number 1 is 81366. That's 81366. For those of you keeping score at home, I suggest you jot that down and make sure to include it in your survey. Our 4 areas that we will focus on in exploring this new attitude that OSHA has implemented starts with its increased funding and inspector hirings. That's going to be pivotal in terms of how its enforcement is going to, I foresee it developing and expanding over the next few years. In addition to that, there was a recent revision to the instance, or several revisions, excuse me, to the instance by instance violation policy. Some of you may or may not be familiar with that. We'll talk about what it used to look like and now what it does look like and what effect that could have for workplace safety and OSHA's enforcement initiatives. As well, too, kind of a minor note, we'll talk about modifications to the Severe Violator Enforcement Program. That went all the way back into September, but it's another, it fits into the pattern of that we're seeing in terms of this new attitude. And then as well, too, an additional revision to electronic data reporting that will, again, continue to allow OSHA to home in on particular aspects of workplace safety and therefore expand or increase its enforcement capacities or enforcement initiatives. We kind of should have seen this coming. In May of 2022, at a congressional hearing regarding OSHA's budget for the upcoming year, Labor Secretary Marty Walsh had one answer when asked about funding priority for the upcoming year. You guessed it. And of course, that should have been a signal that we might have an expansion of OSHA's operations. Because of course, any agency is going to depend largely upon or cannot proceed without the necessary funding to carry out any initiatives it may or may not have. So certainly there was at least a signal there. We'll talk further about what that means for the 2024 budget as well. But in essence, I think what we're seeing between the signal from OSHA itself and the Department of Labor, and then as well in some of the actual inaction of measures related to that budgetary increase is just a general expansion of OSHA throughout the years. Some say it's an effort to get the administration back towards pre-pandemic levels, both of operations and enforcement. But I think there's a little bit more to it. In order to really fully explore this expansion, it requires really taking a look at the numbers. So let's get into that. This right here outlines OSHA's budget year by year. There has been a steady expansion, at least in raw dollars, of the amount of money it's receiving from Congress to carry out its operations. Certainly for 2024, it's seeking even further increased funding. It would be an increase of about 16% if it gets all that it wants. That's unlikely to happen. As we know, these in all of the different investigations I did about all the prior budget numbers, there was always a proposal that, of course, far outstripped what the actual numbers were. And as well, too, some of these increases, when you, depending on how you calculate it, when you make an adjustment for inflation, may not necessarily reflect a true or substantial increase in the amount of money it has. But nonetheless, there is a push from the agency, as with any agency, to get more funding. And that push for more funding, I think, is related to its intention to expand the role that it's playing in workplace safety and the role that it wants to have in terms of carrying out its enforcement initiatives. So I think that there is at least something to keep track of. They're pushing for more money. What's going to happen for this year is anyone's guess. We all know the situation in Congress. There are all kinds of budgetary issues that they're facing that are tethered to all kinds of political infighting. So, how this will all play out going forward, one can never know, but I think there are other indicators in addition to the budget that show that OSHA is certainly oriented towards expanding its role in workplace safety. And that other indicator is the number of inspectors it has. Certainly, increasing staffing depends upon making sure that it gets the money. And in recent years, OSHA has done just that. You can see that it has exceeded even its pre-pandemic levels with the number of inspectors that it has in 2022 compared to 2018. And in fact, 18, 19, featured a decline in the number of inspectors. I think some of the numbers there in 2021 obviously are pandemic related, but nonetheless, those numbers, and one of the things to keep in mind is that those numbers in 2018, 2017, 19, et cetera, are far below where OSHA was 15, 20, 30 years ago. In 2010, it had, for example, in 1982, it had over 1,400 inspectors. In 79 had 1,400 inspectors, 82 down to 1,000, 2010 back up to 1,100, 2016 952. So you can see it was always hovering around 1,000, especially in the past 10, 15 years. And so therefore this in the late 2010s was a noteworthy decline. And so it is, some have said that OSHA is seeking to get back to pre-pandemic levels. I think it's exceeding that, but still not approaching some of the levels it had in prior years. Regardless, for us in the near, in the most recent times, you're going to notice a change. There are going to be more inspectors out there. Two hallmarks of this development, though, to keep in mind. Yes, more inspectors gives OSHA a greater enforcement capacity, but with new inspectors, there is, of course, an onboarding process. Some say it takes 2 to 3 years for an inspector to fully get up to speed in terms of understanding the role, the regulations, and how they are enforced. As a result, with this influx of new inspectors, reports I've heard, and I think it's reasonable to state, there could be a potential for those carrying out the inspections to maybe not have had a full range of experience as other inspectors have, or you may have variability in the range of experience that inspectors are going to have, and therefore a range of interpretations as to how to enforce OSHA's regulations. Some of you may or may not know OSHA's inspectors, they operate on a field manual that gives detailed instructions on how to identify and cite workplace violations. But of course, that field manual is hundreds of pages long. The training certainly is extensive, but even so, it's not going to replace that real world experience. And so there's a potential that you're going to run into complications with inspectors, going through the learning process. What effect has that had? This increased both funding potentially and increased inspectors on inspections. You can see a lot of the inspections themselves have been subject to pandemic-related influences. Before the pandemic, we were hovering around just over 30,000 inspections. We're getting back to that number now. That makes sense. There was a decline during the pandemic for two reasons. One, certainly there were lockdowns that had an effect on federal government operations, but as well, the lockdowns affected employers also. And so therefore, there weren't as many places to go out and inspect. And so as a result, you see some of those numbers. But again, although we are already at pre-pandemic levels, that doesn't mean OSHA has stagnated in terms of its intention to go out and hire. There are initiatives to expand the number of inspectors for 2024 by about 100. And so therefore we can expect 100 to 150, new inspectors. And therefore we can expect that these inspections are going to rise above pre-pandemic levels. So this isn't necessarily about a recovery. There is an expansion going on. You can see it reflected. I think there's a lag in the total number of citations because as we talked about, some of those new inspectors are just coming on board. They're still going through training. And so there may not be as many of them out there, although the inspections are getting up to speed. We haven't quite seen the numbers so far tick up with citations, but I think that it's going to follow as a matter of course. And so again, you can see there was a dip. A lot of those dips in terms of citations were pandemic related, not 2019, of course. And that was part of a shift during the Trump administration for a reduced involvement and a reduced capacity of OSHA to carry out enforcement initiatives when it comes to workplace safety. So to put all this together, and I think probably some of the conclusions or the running themes that you've seen and conclusions, therefore, throughout this inspection of the numbers are, look, there's going to be an increase in funding, or certainly an attempt to grab more funding. With that funding, there's going to be an initiative to increase the number of inspectors. As inspectors increase, there will be a greater number of inspections, and those inspections then are going to mean a greater number of citations. For those of you keeping score at home, this is what those citations can look like. These are maximum penalties. As some of you may or may not know, OSHA takes into a number of considerations when issuing a penalty: frequency of violation, size of the company, overall capacity for carrying out abatement. There are a number of different measures that OSHA is going to look at in terms of how to assess the maximum penalty. But of course, these are the numbers that they're dealing with in terms of the highest amount of fine that it can issue on for any particular citation. Added to the fines that can be levied is now the number of citations and the number of actual fines that can be levied against employers for any particular citation. And that number of fines, so in addition to the increase in the amount of the fines, the increase in the number of fines could come into play through something called the instance-by-instance policy. So in other words, these numbers here, just to go back for a second, as some of you know, they increase every year. They're pegged to inflation. There's a yearly publication that OSHA puts out in January with the revised numbers. We can expect those to go up as with the rate of inflation. But now what instance by instance is going to do is increase now the number of citation, or the number of fines that can arise and flow from a citation. So let's talk about what this policy is. Essentially, it refers to an internal enforcement policy. There's no regulation on this. And what it does is a directive to the inspectors, the compliance, occupational safety, and health officers, to issue separate citations for each violation that inspector identifies. That's not always the case. Sometimes each particular violation does not necessarily always lead or yield a separate citation. And so OSHA has always had the capacity to issue instance by instance citations. What's happened now is they've expanded when it is appropriate to do so. Under the old policy, way back in 1990, OSHA had a narrow set of parameters that it would employ when deciding to cite a violation on an instance-by-instance basis. And back then, under the original policy, you would do it violation by violation if you had this combination: a clearly willful violation, and actually multiple of them, and one or more of any one of these instances. So you had to have willful violations and one or more of the following: either fatality, catastrophe, or serious injuries, multiple of those. Okay? Persistently high rate of injuries or illnesses at that particular employer. So some sort of past history of workplace safety issues, or an extensive history of prior violations, or evidence of any kind of intentional disregard of health and safety responsibilities, or perhaps bad faith in performing any of the obligations under the OSHA Act, or any number of violations that would undermine a safety and health program at the company. So with any of these instances, that would trigger, any one of these factors would trigger an instance-by-instance violation. But I think the overall takeaway from this is, look, this is intended to go after pretty egregious violators. It was a tool that OSHA had available to it that it could use when there were certain employers it really needed to have a capacity to issue something beyond the typical 4 to 5 figure penalty that would often accompany a citation, at least among the ones that I've seen in the past 5 years or so. But all that changed back in January. By way of a press release and an internal memorandum, OSHA announced a new instance-by-instance policy. And that's really all it took, is just this internal directive to how inspectors were to interpret both the existing regulatory scheme and then its observations of what is going on in the workplace. And so what they did is they altered then the factors that an inspector could use in determining when to or not to use the instance-by-instance policy, or when to issue a citation on an instance-by-instance basis. And the factors evolved into this: any willful, repeat, or failure to abate violation within the past 5 years. Okay? It's a big shift. Any violation. Willful and repeat violations, especially in certain industries, in certain high-risk industries, happen more often than employers would like. It's especially for certain industries that are doing the same thing over and over again, where you have the same activity. Roofers come to mind, for example. It's a very avoiding repeat violations can become a particular challenge, and so therefore, this is can be a significant expansion for certain industries and certain businesses in their operations. Failure to report. We all know 8 hours on an amputation or hospitalization, 24 loss of an eye. 8 hours on fatality, 24 on hospitalization, amputation, or loss of an eye. Any failure to do that. And it wasn't clear whether they mean the failure for the particular inspection or any failure would trigger then instance by instance, the application of the instance by instance policy. Citations that relate to a fatality or a catastrophe, and then also a record keeping violation. So if there's a citation with respect to record keeping that's related to an injury or illness that results in a serious hazard. Okay, so that one really caught a lot of people's attention. There was quite a lot of murmurs about how record-keeping citations could then trigger this instance-by-instance policy, because very often, record-keeping citations can result in, like you saw before, some of either the de minimis or other than serious violations that you saw listed in that chart before, in one of the earlier slides. Now, so with that expansion of the use of it, there was now then a narrowing of its application, or of the application's policy, because this expansion is only going to apply to certain industries and certain, hazards. I take that back. Fall protection for sure, trench safety or excavation safety, respiratory protection, machine guarding, controlled confined spaces, and lockout tagout for de-energizing machinery, for de-energized machinery, and so in that respect, then, that was sort of the counterbalance, right? You have much easier ways of applying this instance by instance policy, but then a narrowing of the scope as to, when then an inspector can then employ that expanded use of instance by instance citations. However, I sort of feel like saying not so fast. Let's take a look at something. If you drill down into the numbers, you can see that it still might not have the limitations that perhaps it could be sold as. We charted the number of citations, full total number of citations that OSHA issued October to September 21 to 22, the most recent data here that we've got. And you can see of the 40 to 45, or sorry, almost 50,000 citations or so issued in that period, a vast majority are in the construction industry. And then, of course, manufacturing, about just under 50% less than the number in construction. And they make up a bulk of the violations that you're seeing. Now, what's interesting about these numbers is that with the large number of citations in construction and manufacturing, which one would expect, you're dealing with dangerous circumstances, dangerous machinery, all kinds of potential for workplace injuries. We would expect those citations to be high, but then what you want to do is cross-reference it with then the most frequently cited violations. And you can see here, this is the OSHA's visual display for most frequently cited violations in 2021, and now even in 2022, basically the same list. And we put that list together here and identified that in that list of top 10, every single one of them involves either construction or manufacturing, and 3 of them involve both. And so you can see that the greatest number of citations go toward construction and manufacturing, and then even the top 10 citations, again, construction and manufacturing, as one would expect. But what's interesting is then when you cross-reference it with that list before of the areas where the instance by instance policy is to be employed, you can see then that 4 out of 6 of them, again, of those targeted areas, arise in construction and manufacturing. So it's fair to say that the instance by instance policy is going to disproportionately affect the construction and manufacturing industry. Admittedly, the statistics alone suggest that any kind of change in enforcement in OSHA is going to do that. But I think here, the limitations on the instance by instance policy don't mute or in any way, I think, lessen the effect that the instance by instance policy is going to have on those particular industries. So what does that all mean in the real world or for a practical application? Well, let's take a look at that. This is a citation, and you can see there that this is how some of you have seen a citation issued by OSHA. They come in this form. It lists basic information about the violation identified, and in particular details about what the inspector observed. And of course, it'll have the classification of the citation, the regulation violated, description of that regulation, and the hazards that were identified, abatement measures, and then an abatement deadline, okay? And a proposed penalty. Final part of that. What you see in old citations is that they would often identify that employees were observed, conducting certain activity. And in other words, that you can have one citation for conduct involving multiple employees. What the change in the instance by instance policy, as you can expect, and it was outlined in the memorandum that OSHA issued, is that now there's a greater use of it, an application of citations on a per machine basis, for example, on a per location basis, on a per entry point basis, or a per employee basis. Okay, so circling back to those target industries, instead of just one citation for overall machine guarding a plant, it's each particular machine, or each location on a machine, or each employee that was exposed to a particular machine that didn't have sufficient guarding. And so what does that mean? Well, this is kind of a silly example, but we decided to pull this just to illustrate. Technically speaking, in addition to all some of the vast number of violations that you can see in this photo, I wanted to just focus our attention on the fall protection issue. You've got folks there at elevations above 6 feet without any kind of protection against falling, in addition to all the other certainly serious workplace hazards that we're seeing here. And as you see, we've got 6 different individuals who can be exposed to this fall hazard. Obviously, the right thing to do here is to make sure that everyone's behind a railing, and that's just not the case here. The only time that this any kind of behavior in an environment such as an industrial facility like this would be acceptable is if those folks were on a ladder, and that's not the case here. So how do we then assess how that particular violation, setting aside all the other ones that we see, the violation for fall protection, could be analyzed? Well, under the old system, of course, we're going to have a serious violation of fall protection issues, and we're going to give them the maximum penalty just because of how egregious that could be. And that's going to result in a citation for the maximum amount. But under the new policy, right, we've got a serious violation. We're going to have the same maximum penalty given the circumstances, but we had 6 employees. And so therefore, you now have a maximum penalty that's $15,625 multiplied by 6. And you can see you have a much different business decision on your hands when you factor in the instance by instance policy. And so therefore, it is incumbent upon employers to take seriously the potential liability they could be facing if they have a workplace safety issue that can fit into all the different circumstances and boxes that we've gone over in this instance by instance policy. And I think too, something to consider in terms of talking about how OSHA is going to enforce this policy. I think its own words speak for itself. We pulled a whole bunch of quotes from both the memorandum and the press release, and you can see that OSHA is implementing this policy for primarily, as one would expect, deterrence, an additional tool for deterrence. It wants to increase the effectiveness of the penalties just overall, and really also give it the mechanisms, the tools that it would need to target where it thinks increased citations are needed. It really is, you can see, is to discourage noncompliance. What I think strikes me about all of OSHA's words is that there's quite a bit of subjectivity in all of this. And certainly, its mission for workplace safety, certainly we all buy into that. It is all important to any industry, to any business. But I think we can anticipate that there is going to be an expansion because there is the language that it's using suggests that they're going to want to reach for and take advantage of this tool where OSHA thinks it's necessary. Now, that doesn't necessarily mean that use of that tool is proper. One of the things I always like to point out is that with any citation, it's an allegation of a violation, not necessarily a conclusion. One of the things, too, that came along with this, and OSHA had to address this as sort of arguably a corollary to the revision of the instance-by-instance policy, is the grouping policy. Typically, where circumstances gave rise to multiple violations, OSHA would just group the violations together. Some of you, maybe unfortunately, some of you have seen this. You would have a penalty with an abatement and then several other items with no penalty because they sort of were all interrelated. So you'd have one for HAZCOM, for example, in this instance here, that would be, usually you see it as citation 1, item 1A, and then items 1B and 1C that are related also to hazardous communication, also falling within that regulatory framework, in that particular area of the regulatory scheme, you would get a zero penalty violation as well. It would just sort of take all those different violations that are identified, categorize them together, and just issue one citation or excuse me, one penalty for that violation. But what the revised grouping policy said, and this was sort of to pave the way and make sure there was consistency with the new instance by instance policy, is that again, by way of a unilateral revision through an enforcement memo, OSHA said that the inspectors could refrain from grouping under particular circumstances if the worksite conditions gave rise to separate and distinct violations. Sounds like instance by instance, of course. And as well, if there's different conduct that could give rise. So either separate and distinct violations or different, worksite conditions or different conduct, either one of which, and that harkens back to per machine, per employer, per violation, as well too, if grouping would permit multiple other than serious violations to lead to a serious violation, then you could group. So you can see the revision of the grouping policy, one way or another, gives at least the inspectors a larger avenue or more avenues, take your pick, to enhance the enforcement measures that they want to take in a particular inspection. As well, too, there was a revision to what's called the Severe Violator Enforcement Program. I hope none of you have experienced this or know what it is, but it is a program that allows OSHA to take supplemental and basically inspection measures, among others, and abatement directives to address repeat or willful violators or those who don't enact abatement measures to the point where it can be deemed a refusal. It's got many features. Your enrollment in the program, none of which are wanted. You're on a list publicly of those, along with other establishments that have been deemed to be severe violators. There are follow-up inspections, like we mentioned, both at the incident site, that is to say where a violation occurred that gave rise to membership into the program, but then also any other location that the employer might have. Usually a 3-year program, but enhanced abatement can get you out of it. Under the old system, membership into the club, so to speak, or it was applied to employers who had fatalities, 3+ hospitalizations, egregious matters, potentially release of highly hazardous chemicals, or 2+ repeated or willful in a high emphasis program. Okay, so any of those areas, such as fall protection, for which OSHA had created an emphasis program. But the new rule changed how you get into this club, changed the scope of the SVEP. Now it's any fatality or catastrophe related inspection with either one or more willful or repeat, or a failure to abate notice for a serious violation related to either a death or 3 hospitalizations. Kind of convoluted, but the end result of all of this is that it expands where the circumstances under which an inspector is directed to at least consider, if not enroll, an employer in the SVEP. As well, too, for a non-fatal or non-catastrophe inspection, if there are 2+ willful repeat violations or failure to abate notice for a high gravity violation, that too can earn an employer enrollment in the SVEP or any egregious violation. So you can see with this expanded policy, there's going to be greater discretion that OSHA can use to bring employers into the program and get them on the list. I think this is an old list from somewhere, but you can see that there is public information that's provided about those who are in the program. And so there is, this is one of the mechanisms that OSHA will use. And certainly, with that expanded role in the program, there's a greater potential, for folks to find themselves in this program. And again, it fits with our larger theme of an expanded enforcement measures that OSHA is employing. Interestingly enough, those also came about in something called electronic data reporting. Some of you may or may not remember, I suspect some of you may be involved in doing this, but in 2016, OSHA created a program that required certain employers or certain establishments to submit not only keep their OSHA 300 and 300 log, the 301 incident report, and the 300A summary report, but also to submit certain information from those record-keeping documents or record-keeping forms to OSHA electronically. And initially, as you remember, the rule was broke down by the number of employees in an establishment and had different requirements for each. Some only had the 300A summary report, some had to do everything, and some had no requirements at all, even though, as we know too, 10 or more employees triggered the record-keeping requirements. It was a little distinct from the record-keeping. This was now the electronic data from those records and the submission to OSHA. Of course, this policy created a little bit of pushback from employers. In particular, they worried about information from the 301 forms or even the 300 log, giving away confidential employee information. There was pushback as well that there might be a certain unfairness in employers having their data put out there. And so eventually, the compromise was reached, and first by way of just enforcement, and eventually a revision to the rule that just everybody had to do the 300A form. And that is, and remember, it was 20 to 20 establishments with 20 to 249 employees in high-risk injuries, and that was on Appendix A to the rule. And then those who had 250 more employees, again, same policy. So those are the ones who had the 300A requirement, submission requirement. And so it just meant at the end of every year, you took out your 300A form and you put in a little bit of data for OSHA, you submitted it, and everybody was happy and you were done. Now there's been an expansion to bring back at least some of the 300 and 301 data submission. Rather than those employers or types of employers listed on Appendix A, now we're turning to a whole new appendix of business types who then are subject to this expanded rule. And of course, we've gone a little bit, we've expanded also the size of those businesses to establishments with 100 or more employees. So it creates a new band of electronic data reporting requirements. And in that respect, then, you're expanding both the number of folks who have to report and then also the type of data that's being reported. Where this will lead in terms of future revisions to electronic data reporting rule, haven't seen anything so far, but certainly this is a response to OSHA's desire to have additional information about workplace safety hazards and safety incidents to enhance its mission. And we'll talk about how that plays out in a second. But what does the rule require? In addition, we talk about this, the expansion for 100 plus employers. We talk about, I think we already get, this is an electronic submission. And that information is going to include the date, the physical location, the injury. I should say this too, that the specific information required to be reported was modified in response to some of the concerns about privacy issues. So it is going to have details about the injured worker and how the injury occurred, but personal information will be withheld. You also have to provide the company's legal name, but yeah, we can. But certain personal information are going to be withheld for privacy concerns. And only a limited amount of data is going to be presented on OSHA's website. But there will be information about this put up on OSHA's website. The initiative and the reason for this electronic data reporting and for that detail is that OSHA intends to use this information to identify recurring hazards, whether it's in a particular industry or whether it's in a particular there might be a particular tool or machine that's causing a common occurrence or common set of injuries. OSHA will use that as a way of narrowing the scope or narrowing how it conducts workplace inspections. With this data, it can go after where safety hazards are occurring. Same thing too with information about in particular employers. OSHA can then target, can engage in targeted inspections for particular workplace hazards or employers that it thinks where there could be grounds for performing an inspection based upon information that it's obtaining from electronic data reporting. One of the things too, as well, is that those employers who do not submit electronic data as required also end up, and this has always been the case since the rule was created, end up on OSHA's list of programmed inspections. And so it's between the data, or those who are not submitting data, that programmed inspections, the focus of a programmed inspections, can be refined. One of the things to keep in mind, just from a compliance standpoint, the rule governs establishments, not a company. Those of you familiar with this requirement probably get that, but the definition of establishment is just a workplace. So it's not the employer in its aggregate, but each particular location. I think, drawing on the construction industry, for example, or even in manufacturing, for each facility, you would measure the number of employees, not the overall number of employees that exist company-wide. Whether you are governed by requirements that are triggered by Appendix A or B depends upon the NAICS code, North American Industry Classification System code that a particular employer uses. So just be aware of what code you use in other circumstances, and that'll determine whether you fall into any of those governed or where requirements are triggered by Appendix A or Appendix B. Remember, OSHA is still using the 17 codes. And make sure you're consistent across your OSHA and non-OSHA submissions, and that you've identified, make sure that you're clear about what codes you're using. And remember too that there might be different codes that you use across different establishments. I've seen that arise in circumstances, and that will affect the establishment's reporting requirement. And as well too, there can be the connection to the instance by instance policy. Is that this is another expansion of OSHA's involvement and enforcement regime. As well too, you can see its own words and information about what it is and is not going to report. The reason it's doing this too is for multiple levels. They also want to get information out there for employees to make decisions about hiring, or at least job acceptance. And it also allows different, on business-to-business transactions or interactions, it allows those companies or those businesses to make a decision, an informed decision about with whom they're going to work with. As well too, you can see that, of course, the data is going to fall into its strategic outreach to identify particular high hazard instances or industries like we talked about earlier. What does compliance look like? First of all, make sure you remember your deadline, March 2nd of the year after, obviously, okay? Especially if the data is going to be based on the 300-day form, you're not going to compile that until January, February of the following year. And so as a result, they've given March 2nd as the deadline. OSHA has its own, they call it the ITA, the Injury Tracking Application. And you will log in to do that. You create an account with OSHA. They actually have a sandbox where you can make you can log in, not actually you can enter a login information and access an application that isn't the official tracking application, but it's like a test system that you can use to make sure that you understand the process for submitting the data, and then prepare yourself for doing it. Actually, I think that was a feature that they had, especially when the rule first came out, to allow people to make sure they understood the process before actually submitting information to OSHA. However, I think most people are familiar with the 3 ways you can do it. You can manually enter data on a web form that OSHA provides. I think if you're a smaller establishment or a smaller company, you only have 300A information, that might be one way of doing it. You can create a CSV file and upload it that way, or you can have your own application programming interface, your own software app that can connect to, take your automated record keeping system and connect to OSHA's system and upload the data that way. One of the features of this, unfortunately, and OSHA's been clear about this, is conceded this in one way or another, is that you get to a compliance by shame. With this increased data, there's more targeted and purposeful inspections, I think, as we alluded to earlier. This publicly available data, too, runs into a problem in that it is only giving a limited set of information about each particular instance, or even the summary report on a 300A. As we all know, an incident itself does not necessarily mean that there was a violation by an employer of any particular safety standard. And so as a result, this public data can lead to a conclusion about an employer's safety record that may not reflect actually its actual commitment to safety, or whether it's violated any standards at all. Even if there is a citation against an employer, like I said, citations are alleged violations, they're not confirmed ones. And so as a result, both the presence of citations, which, as we know, are publicly available, but even this data can lead to unforeseen and perhaps even unjustified conclusions on the part of a viewer or a user who may not realize that an incident rate or prior violations don't necessarily reflect actual breaches of safety standards, whether OSHA's or otherwise, an employer's particular standards. And so therefore, we've got incomplete decisions both by customers, employees, and others who are evaluating any particular business or company. What's the takeaway from all of this? We looked at a number of different ways in which OSHA has expanded its reach and its involvement in workplace safety and employer activity. I think what people need to do is make sure that you're preparing for inspections. I do have an office here in Philadelphia, so of course I had to reach back to Ben Franklin, but I think it's apt advice. There are all kinds of different mechanisms and measures that a business can take to prepare for an OSHA inspection. And in fact, I give a whole nother webinar or discussion, an hour-long discussion of all the different things a business can do. So to the extent you know of those, or to the extent you've implemented them, check up to make sure you have. If you haven't, contact me or others about making sure that you're up to speed in terms of preparations for OSHA inspections. Make sure that your safety program preserves defenses. So in other words, do you have an appropriate incident report template, or the appropriate policies in place in terms of workers' requirement, or employees' requirement to follow workplace hazards, or follow workplace standards, workplace safety standards? I'll get it. And in addition, do you have the right monitoring systems in place where the management is involved in ensuring that workplace safety standards are being followed by employees, and appropriate disciplinary measures are being enacted for those who do not? Those are all elements of different defenses that an employer can make in response to an OSHA citation. Again, subject of a whole nother webinar, about an hour long, and but certainly reach out to those in your network about making sure that your safety program is shored up in that regard. Before we go any further, I'll let you know we now have CLE code number 230694. CLE code number 230694. Take a look at your contract safety clauses. A little targeted more towards construction, but to the extent that any of you are involved with third parties out there, or customers, in a division of management and control and responsibility for employee safety, make sure that that's delineated clearly in your contracts. This then reaches back to or pertains to OSHA's multi-employer citation policy, and that's one of their avenue you want to make sure that you're shored up on, both in terms of the clauses, and then also your understanding and a due diligence you may have or you may have conducted. You want to make sure you're updated in that investigation and that exploration and collection of information about the safety of the business with which you have contractual relations, to the extent that there is a shared responsibility or potential for shared responsibility for workplace safety. Obviously, it's easy to talk about this in more defined terms on a construction project. What that means is, what responsibility does the owner, the GC, or the subcontractor have for a particular project? But for example, if you've got delivery and you work with if you're an industrial facility and you have a contract with a delivery service, make sure that you've delineated who's responsible for workplace safety with respect to pickup and delivery, just in the same way you might talk about risk of loss for delivered goods. As well, too, consider conducting a safety audit. Have a professional come in and identify your performance, your company's performance with respect to workplace safety standards and its own policies regarding workplace safety. Similarly, there are those in your network who can help. And there are a number of resources that I recommend whenever I give a seminar, but in particular here in anticipation of a greater role, of perhaps a potential greater role from OSHA and its involvement in workplace safety issues. Start with your insurance broker. Your GL and your workplace workers' comp policies obviously both pertain to workplace safety, and therefore your broker has an interest in making sure that you're addressing safety properly. And as some of you may or may not know, oftentimes your broker can provide services, complementary services, either in providing policies or performing inspections. I'll caution in using that though, because I have definitely seen instances where policies or inspections are provided, and may not always be targeted to a particular workplace need or workplace operations. And so it's great to get that information, but make sure that you have it vetted properly, either through your own in-house safety director, an outside safety consultant, or perhaps others in the network that we're going to talk about. And that brings us to safety consultant or coordinator. If you've got somebody in-house, certainly make sure that person understands the expanded role that we anticipate from OSHA and has thought carefully about workplace safety and the potential hazards that exist and how best to address them, whether it's through modifying policy, increasing training, increasing supervision, or perhaps changing the nature of the disciplinary policy. All four of those levels are key to defending against an OSHA citation. Make sure that you touch base with your safety coordinator. As well, too, experienced OSHA counsel. I often say that my role is sort of supervisory, almost like a ringleader, making sure that all those different other parts that we talked about, safety consultant, your insurance broker, et cetera, making sure that everybody is on board and on the same page with respect to, and make sure there's coordination among all those different resources with an eye towards the regulatory scheme and making sure that all of that is directed towards maximizing defenses and preventing violations in the first place, or making sure that workplace safety complies with the existing regulatory scheme. So there we are. I said I'd leave a few extra minutes for questions. And so I will do that now. And happy to take any questions that folks may have. I see that there might be some there. And I'll turn to those now. And if there are other additional questions that people want to have, just post them in the chat. In the Q&A section. Make sure to click on the Q&A button. I think that's where we'll look first to questions, and I think that's helpful in terms of keeping ourselves organized and on track here. The first question says, does the instance-by-instance policy apply to citations where no standard is referenced? General duty clause. Remains to be seen at this point. Not entirely sure. That's a very good question. I have not seen anything in the policy itself that would state that could be a problem. Any kind of general duty clause is going to have a citation itself. And so therefore, just as the instance by instance policy applies to violations that are direct violations of an existing standard, so too a violation of the general duty clause would seem to fall under that rubric. The policy is very new, as you know. It was enacted in January of 2023, but it didn't go into effect until March. So, and remember too, we have a 6-month window, 6-month statute of limitations. So between inspections, between an inspector goes out to a site and makes the inspection, and when the citation is issued. So we're just now going to be seeing citations that arise or that implement the instance by instance policy. So it remains to be seen at this point. I've rarely seen OSHA issue a citation well within the 6-month window. So I think only just now we'll be getting to some of those citations. I don't see any other questions in the Q&A. I'll keep it open for just 1 second longer. And hold it open for a minute longer. We are at 1 o'clock. I'm happy to go over, but I want their questions and answer. If there's nothing, if everybody's good and we're happy, we can move on with the rest of our day. So we'll hold out till 101. How's that? Just in case anybody thinks anything. And then finally, of course, you have my contact information. If anything occurs to you further on down the road, by all means, reach out at any time. Happy to discuss any of these issues and answer any questions folks may have. I'd like to take this moment to thank everybody for participating. It was enjoyable for me to be able to talk about these issues and share with you some of the information we've gathered. And of course, make sure and provide a way that it's connected to your day-to-day operations and your day-to-day business business issues that you're facing on a daily basis and any of your safety concerns. If any of those arise in the future, again, please don't hesitate to reach out. And thank you so much for participating. Have a good rest of your day. Thank you so much, everybody.